Maybe try speaking proper English. This is a court of law, not a whatever it is you're used to." The words hang in the courtroom like smoke from a pistol. Scattered laughter rises from the gallery. Not loud, just enough to fill the silence where dignity should have been. A black woman stands at the plaintiff's podium, documents steady in her grip, not trembling, never trembling. She watches the judge lean back in his leather chair, that smile curling across his face, the smile of a man who has said these words before, who has watched other women crumble, who has never once paid a price for any of it. Judge Warren Kessler checks his watch, already bored, already ruling. He has no idea he just ended his own career, because Harper Riley is not a paralegal, not a law student, not some woman from the neighborhood as the clerk had whispered earlier. She is the senior advisor for Judicial Nominations in the White House Counsel's office, and his name has been sitting on her desk in Washington for 3 weeks, under consideration for a lifetime appointment to the Fourth Circuit Court of Appeals. She writes 3 words in her leather notebook, underlines them twice. The bailiff smirks from the corner, hand resting on his weapon. The opposing attorney shuffles papers, hiding his grin. The court reporter's fingers pause over the keys, just for a moment, before continuing. Harper doesn't look up, doesn't react, just writes. The judge notices the notebook. His smile falters for half a second. Not guilt. Not yet. Just the faintest recognition that something in this room has shifted. He clears his throat. "Do you have anything else to add, Ms. Riley? Or can we move this along?" She closes the notebook, meets his eyes. "I have quite a bit to add, Your Honor, but not today." Yet. If you're new here, hit subscribe and turn on notifications. Trust me, you're going to want to see what happens when this judge finds out who he just humiliated. 3 weeks earlier, Harper Riley checked into an extended stay hotel off Independence Boulevard in Charlotte, North Carolina, the kind of place that asked no questions and accepted payment in advance. Clean enough, anonymous enough, perfect. She unpacked with the precision of someone who had done this many times before, clothes arranged by day, legal pads stacked by purpose, toiletries lined along the bathroom counter in exact parallel rows. Before touching anything else, she photographed the room from 4 angles, timestamp visible, evidence of condition upon arrival, old habit, the kind learned from years in a profession where documentation was survival. On the desk sat a manila folder sealed with red tape that indicated classification level. Inside, a photograph of a white-haired man in judicial robes, distinguished features, confident posture. Below the photograph, a name typed in government courier font. Warren Kessler, Superior Court Judge, 4th Judicial District, Mecklenburg County, North Carolina. Under consideration for nomination to the United States Court of Appeals for the 4th Circuit. She didn't read the rest. Not yet. She already knew the file by memory, the 18 years on the bench, the law review articles, the glowing letters from the State Bar Association, the quiet endorsements from senators who owed favors. What she didn't know, what the file couldn't tell her, was how he behaved when no one important was watching. That's why she was here. The next morning, Harper arrived at the Mecklenburg County Courthouse at exactly 8:15 a.m. Professional dress, modest blazer, sensible heels, nothing that screamed money or power. She carried a folder of documents related to a landlord-tenant dispute over a security deposit. Real case, real stakes. Filed under her own name 3 weeks prior, timed precisely for this assignment. The security line moved slowly. Harper observed everything. Which guards were thorough? Which waved people through? Who got stopped for additional screening? A white man in a business suit passed without pause. The guard nodded, smiled. Behind him, a young black woman with a baby stroller was directed to the secondary lane. Harper filed that away. When her turn came, she placed her bag on the conveyor and stepped through the metal detector. No beep, clean scan. "Step aside, ma'am." The deputy pointed to the secondary screening area. His name tag read Riggs, badge number 4471. "The scanner didn't activate," Harper said, keeping her voice neutral. "Random selection." Deputy Riggs didn't look up from his clipboard. "Won't take long." It took 11 minutes, longer than the actual scan. By the time she gathered her belongings, the white businessman was already 3 floors up, sipping coffee from the courthouse cafe. Harper noted the time, the deputy's name, the badge number, the duration. She said nothing. The clerk of court's office occupied the 2nd floor, a maze of filing cabinets and harried staff members. Harper joined the line for small claims filings, folder in hand. The woman at the counter had been there 22 years. The nameplate on her desk said Patricia Loomis, senior clerk. Her eyes moved over Harper with the practiced assessment of someone who sorted people into categories within seconds. Next. Harper approached, placed her documents on the counter. Filing for small claims. Case number 2024-SC-08847. Patricia glanced at the papers. Her expression shifted, subtle but unmistakable. "You filled out the wrong form." Harper had triple-checked. "This is Form 7A, the standard small claims complaint." "This is the old 7A. We updated our forms last month. You'll need to download the new version from our website and start over." Patricia slid the documents back across the counter. "Back of the line when you're ready." Harper didn't move. "I downloaded this form yesterday, from your website. The header matches the current date." Patricia's smile tightened. "Well, the system shows the update. Nothing I can do about that." "May I see the current form? To compare?" "The current form is on the website, which you should have checked before coming here." Patricia looked past her. "Next." The man behind Harper stepped forward, papers already in hand. White. 60s. Golf shirt under his sport coat. Patricia's expression transformed, warm, accommodating. "Mr. Hendricks, here to file the Anderson motion? Let me get that expedited for you." Harper stepped aside, didn't argue, didn't demand, just photographed the forms spread on the counter, including the current version Patricia was now offering Mr. Hendricks. Same form, same header, same date. She'd return tomorrow with identical documents. Patricia would have no memory of this conversation, but Harper would. The courthouse cafe served burnt coffee at $3 a cup. Harper ordered anyway, found a table near the window with a clear view of the elevators, and opened her laptop. The afternoon session would begin at 1:30 p.m. Small Claims Court, Judge Warren Kessler presiding. She wasn't on the docket, not yet. But observation required no appointment. By 1:15, she sat in the gallery, 3rd row, left side, unobtrusive angle. Other observers dotted the wooden benches, a law student with a notebook, a journalist checking her phone, family members waiting for their relatives' cases. Judge Kessler entered at 1:28, robes billowing. The bailiff called the room to order. Everyone rose. Harper watched. The first case, Johnson versus AAA Auto Sales. A black man in his 50s claimed the dealership had sold him a car with a faulty transmission, knowing it was defective. He spoke carefully, documents arranged in a manila folder. The dealer's attorney, Victor Stahl, according to the docket, interrupted 3 times during the plaintiff's opening statement. "Objection, hearsay." "Objection, speculation." "Objection, lack of foundation." Each time, Judge Kessler sustained without hesitation. "Mr. Johnson, you need to limit yourself to what you personally witnessed, not what mechanics told you, not what you think happened, what you saw." Mr. Johnson tried again. "I saw the transmission fail, Your Honor. On camera. I have the dashcam footage." "Is that footage authenticated?" I recorded it myself, with my own camera." "Are you a video forensics expert, Mr. Johnson?" Victor Stahl smirked. He knew this dance. "No, Your Honor, but I can testify that I was present when the footage is inadmissible." Judge Kessler made a note. "Continue." Mr. Johnson had no more evidence to present. Everything he'd brought required authentication he didn't know how to provide. The case was dismissed in under 4 minutes. As he gathered his papers, hands shaking, Victor Stahl approached the bench. He shared a quiet word with Judge Kessler. They laughed. Harper wrote, "Pattern consistent with file. Thursday golf games, cross-reference donor records." The second case was another black plaintiff. The third. The fourth. Each dismissed or ruled against on procedural grounds. Each opponent represented by attorneys who seemed to know exactly which objections would succeed. By 4 p.m., Harper had filled 9 pages. The pattern wasn't subtle. It wasn't hidden. It was simply protected. 18 years on the bench. 14 complaints filed with the Judicial Standards Commission. 0 findings of misconduct. Now she knew why. The next morning, Deputy Riggs stopped her again at security. Random selection. Harper didn't argue. She held her arms out for the wand scan, opened her bag for inspection, waited while Riggs took his time examining her legal pads. "Lot of notes here." "I'm thorough." "What case you working on?" "My own." He paused at that, looked at her differently. "Pro se? Is that a problem?" Riggs smiled, the smile of someone who had already categorized her, already dismissed her. "No problem at all, ma'am. Good luck in there." He held her identification for an extra 30 seconds before returning it. She noted that too. The filing window opened at 9 a.m. Patricia Loomis was already at her station, coffee in hand, expression fixed in professional neutrality. Harper approached with the same documents, same form 7A. Filing for small claims, case 2024-SC-08847. Patricia examined the papers, her brow furrowed. "This case is already in the system." "Yes, I filed 3 weeks ago. I'm submitting supplemental evidence." "Supplemental evidence requires Form 12B. I have Form 12B. Harper produced the additional sheet. Completed and notarized. Patricia stared at the documents. Something flickered in her expression. Frustration, maybe. The realization that this woman had done her homework. Fine. She stamped the papers with more force than necessary. Hearing date will be mailed within 10 business days. I'd like to request expedited scheduling, under Rule 7 of the local small claims guidelines. Expedited scheduling is for emergency matters. Landlord-tenant disputes involving wrongfully withheld security deposits fall under the emergency provision when the plaintiff can demonstrate financial hardship. Patricia's jaw tightened. "Do you have documentation of financial hardship?" Harper produced another form. Completed. Signed. Witnessed. The stamp came down harder. "Your hearing is set for 2 weeks from tomorrow. Courtroom 4B, 1:30 p.m. Harper collected her paperwork. Didn't smile, didn't thank her. Some battles were won by refusing to lose. That afternoon, Harper returned to the gallery. Same seat, same angle, different cases. Today's docket included a property line dispute, a contractor payment conflict, and a noise complaint between neighbors. All the plaintiffs were white. All had representation. Judge Kessler's demeanor was noticeably different. He asked clarifying questions. He allowed exhibits without demanding forensic authentication. When attorneys objected, he considered each one on its merits, sustaining some, overruling others. Victor Stahl appeared on 2 cases. He won both. But his victories seemed almost incidental compared to the theatrical demolitions Harper had witnessed yesterday. She added 3 more pages to her notes. Pattern, racialized, application, selective, documentation, growing. Friday evening, Harper left the courthouse at 5:45 p.m. The parking garage was nearly empty. Most staff departed by 5. Her rental car sat on level 3, under a flickering fluorescent light. Footsteps echoed behind her. Deliberate, unhurried, closing. She didn't turn, kept walking. "Busy week for you?" The voice was male, familiar. She'd heard it in the security line. Marcus Henley stepped into her peripheral vision. The bailiff. Off duty now, no uniform, but the posture remained. Military bearing. Calculated presence. He positioned himself between her and the car. "Noticed you watching the proceedings. taking a lot of notes. Harper stopped, let silence fill the space. Judge Kessler noticed too. Henley took another step forward, close enough now that she could smell his aftershave. He's a good man, fair. Doesn't appreciate outsiders coming in, stirring things up, making trouble. I'm a litigant, filing a claim. Sure you are. His eyes moved over her, assessing. You don't look like the usual pro-C crowd. Something different about you. Harper's hand moved to her purse, slowly, visibly. Is there something you need, Mr. Henley? Just friendly advice. He smiled, the kind of smile that wasn't friendly at all. The judge has a long memory. Friends in important places. The kind of people who don't forget when someone comes into their house and disrespects them. Is that a threat? It's a fact. He stepped closer, close enough now that any move she made would involve contact. The garage was empty. Cameras were positioned at the exits, not between the cars. He knew this. He'd chosen this spot deliberately. Some people, Henley continued, they file their cases, take their losses, go home, live their lives. Other people, they push, they dig, they make enemies. He leaned in. Those people tend to have problems. Car trouble, missing documents, security delays. You know how it is. Harper's phone was already in her hand, screen facing him, red light blinking. I'm recording this conversation. Your face, your voice, your badge number from the security checkpoint is in my notes. If anything happens to me, car trouble, missing documents, delays, this footage goes to the State Bar, the Sheriff's Internal Affairs Division, and the Charlotte Observer simultaneously. Henley's smile froze. You have a good evening, Mr. Henley. She stepped around him, unlocked her car, and drove away at exactly the speed limit. In the rearview mirror, he stood in the flickering light, hands at his sides, realizing slowly that he had made a miscalculation. Like what you're hearing? Make sure to like this video and leave a comment. I read every single one. Now let's get back to the story. Monday morning. Mecklenburg County Courthouse. Courtroom 4B. Case number 2024-SC-08847. Riley versus Cornerstone Property Management, LLC. Matter, security deposit dispute, $2,340. Harper arrived at 1:15, documents organized in a leather portfolio. She wore the same modest blazer, the same sensible heels. Nothing about her appearance suggested anything other than an ordinary citizen seeking justice in small claims court. She wanted it that way. Victor Stahl was already at the defendant's table, reviewing notes with his client, a man in his 60s who managed several rental properties in the Charlotte area. His name was Gerald Whitmore, and he had a reputation for extracting maximum revenue from minimum investment. The kind of landlord who charged premium rent for units with 20-year-old appliances and deducted cleaning fees from every deposit regardless of condition. Harper had done her research. Judge Kessler entered at 1:28. Same dramatic entrance, same billowing robes, same expression of faint impatience, as if being here was a favor he was granting to everyone present. Case 2024-SC-08847. Riley versus Cornerstone Property Management. He barely glanced at her. Plaintiff, you may begin. Harper stood, arranged her papers. Thank you, Your Honor. I'm Harper Riley, representing myself in this matter. I've prepared a chronological summary with supporting documentation, organized by the applicable provisions of North Carolina General Statute 4252, which governs the retention and return of security deposits. Something shifted in Kessler's expression. A flicker of surprise, quickly suppressed. Pro se litigants didn't usually cite statutes. They came with emotion and grievance, not precision. Yes, well. He cleared his throat. We'll see if your documentation meets evidentiary standards. It will, Your Honor. Victor Stahl leaned back in his chair, studying her with new interest. Harper continued. On January 15th of this year, I vacated the rental property at 4,847 Wendover Road, Unit 7. Pursuant to my lease agreement and applicable law, I was entitled to a full refund of my security deposit, $2,340, within 30 days, minus any legitimate deductions for damages beyond normal wear and tear. She produced her first exhibit. Exhibit A, photographs of the unit taken on move-out day, time-stamped and geotagged. These images show the property in clean, undamaged condition. Objection. Stahl rose lazily. Lack of foundation. Photographs can be altered. Judge Kessler nodded. Sustained. Ms. Riley, you need to authenticate these images before they can be admitted. Certainly, Your Honor. I took these photographs myself, using my personal phone. I can testify to the date, time, and location. Under Rule 901(b)(1) of the North Carolina Rules of Evidence, authentication may be accomplished through testimony of a witness with knowledge. Kessler's eyes narrowed. Don't lecture me on the rules of evidence. I'm not lecturing, Your Honor. I'm citing the applicable standard. A long pause. The courtroom felt suddenly smaller. The objection stands. Move on. Harper didn't argue. She produced her second exhibit. Exhibit B. My lease agreement, signed by both parties, dated March 1st of the previous year. Page 7, paragraph 12, specifies the security deposit amount and conditions for return. I can authenticate this document as I was present at signing, and this is my signature on page 11. Objection. Hearsay. Your Honor, a party's own documents are not hearsay. They fall under the exclusion for statements of a party opponent, or alternatively as business records if the defendant wishes to contest authenticity. Judge Kessler stared at her. Victor Stahl's smirk faltered. I'll allow the lease. The words seemed to cost him something. Harper pressed forward. Exhibit C. Email correspondence between myself and Cornerstone Property Management, dated February 18th. In this email, the defendant's representative states, and I quote, "Unit was in good condition. Standard deductions will apply." End quote. What deductions? Kessler asked, suddenly engaged. That's my question, Your Honor. The defendant withheld my entire deposit, but never provided an itemized statement of deductions as required by NCGS 42-52. The statute mandates that landlords provide such a statement within 30 days. Failure to comply can result in the landlord forfeiting the right to withhold any portion of the deposit. She laid out the timeline, the certified letters, the requests for documentation, the silence. 47 days passed without any response. Then, on March 8th, I received this. She produced Exhibit D. A single-page letter claiming $2,340 in damages for, and I quote, extensive cleaning, carpet replacement, and miscellaneous repairs. No receipts. No invoices, no photographs, no itemization. Victor Stahl rose again. Your Honor, my client conducted a thorough inspection. Mr. Stahl, you'll have your turn. Kessler's tone was clipped. Something about Harper's preparation had disrupted his rhythm. She continued for another 7 minutes, each claim supported, each document organized, each legal citation accurate. When she finished, she sat down. Kessler looked at Stahl. Your response? The attorney approached the podium with the confidence of a man who had done this many times before. He produced his own exhibits, a folder of photographs showing stained carpets, a scratched countertop, a bathroom with what appeared to be mold damage. These images were taken during the post-vacancy inspection, Stahl explained. As you can see, the unit required substantial remediation. Harper examined the photographs from her seat. Undated. No metadata visible. No indication of when or where they were taken. Objection. Lack of foundation. Stahl smiled. The photographs were taken by my client. He can authenticate them. Then I'd like to cross-examine the witness regarding the date, time, and circumstances of these images. Kessler waved his hand. Mr. Whitmore, when were these photographs taken? Gerald Whitmore, who had been silent until now, straightened in his chair. January 16th, the day after she moved out. And you took them yourself? Yes, Your Honor. Kessler nodded. That's sufficient. Objection overruled. Harper stood. Your Honor, for the record, I'd like to note that the plaintiff's, that is, my objection to lack of foundation, was overruled without requiring documentary authentication, while my own photographs, taken under identical circumstances, were excluded. I'm creating a record of this inconsistency, as is my right under Rule 46. The courtroom went silent. Judge Kessler's face reddened, slowly. Are you accusing this court of bias, Ms. Riley? I'm documenting procedural discrepancies, Your Honor, for any potential appeal. The word hung in the air. Appeal. Judges who were reversed on appeal had their records reviewed, their patterns scrutinized, their nominations questioned. Kessler's jaw tightened. The court will take these matters under advisement. Ruling to be issued within 30 days. He rose, robe sweeping, face fixed in controlled fury. Harper gathered her documents, didn't rush, didn't apologize. Behind her, Victor Stahl muttered something to his client. The words weren't audible, but the tone carried. She had made enemies today. That was fine. She was just getting started. The hallway outside courtroom 4B bustled with afternoon traffic. Attorneys conferring with clients, families waiting for verdicts, clerks shuttling between offices with armloads of files. Harper moved through the crowd, portfolio under her arm, mind already cataloging the morning's events. The sustained objections, the overruled authentication, the moment Kessler's composure had cracked. Ms. Riley. The voice came from behind. Male. Older. She turned. Victor Stahl stood 3 feet away, folder in hand, expression carefully neutral. Impressive performance in there. It wasn't a performance. No. He studied her. I suppose it wasn't. Most pro se litigants can't cite the rules of evidence from memory. Unusual skill set for a, what was it, tenant dispute? Harper met his gaze. Is there something you need, Mr. Stahl? Just professional curiosity. He stepped closer, lowering his voice. You know, my client is authorized to settle. Original deposit plus costs. No admission, standard NDA. This all goes away by Friday. Why would I settle a case I'm going to win? Stahl laughed. Genuine, almost admiring. Win? Ms. Riley, you're in Judge Kessler's courtroom. You're pro se. He caught himself. You're at a significant procedural disadvantage. Because I'm black. The words sat between them like a thrown knife. I didn't say that. You didn't have to. Harper tilted her head. 14 complaints filed against Judge Kessler in the past decade. All from plaintiffs of color. All dismissed without investigation. Did you know that, Mr. Stahl? Or is that just coincidence? His smile faded. You've done your homework. I always do. Then you know how this works, how the system works. You file your appeals, you make your noise, and 6 months from now you've spent $10,000 in time and aggravation to recover $2,000 you'll never see anyway. He paused. Take the settlement. Go home. Chalk this up to experience. Harper's expression didn't change. I'll see you at the next hearing, Mr. Stahl. She turned and walked away. He didn't follow. That evening, Harper drove to a community center in East Charlotte. The building had once been a church, stained glass windows still visible above modern signage. Now it housed after-school programs, AA meetings, and on the third Thursday of each month, a Know Your Rights seminar organized by local advocates. The topic tonight, navigating the court system without a lawyer. Roughly 30 people filled the folding chairs, mostly black, mostly working class, mostly carrying the weight of legal battles they couldn't afford to fight. An older woman with a cane sat in the front row, manila folder balanced on her lap. A young man in work boots leaned against the back wall, arms crossed, expression skeptical. The speaker was Reverend James Okonkwo, tall, silver-haired, voice carrying the cadence of someone accustomed to both pulpits and protest lines. Harper took a seat near the back, listened. The stories that followed were familiar. Too familiar. A woman named Sandra described her custody hearing, how Judge Kessler had refused to let her testify about her ex-husband's violent history. Not relevant, he'd said. Focus on the child's welfare. As if the two weren't connected. An elderly man named Roosevelt talked about his eviction case. His landlord had violated building codes for years, exposed wiring, no heat in winter, mold in the bathroom. The judge dismissed his counterclaim in 4 minutes. Unsubstantiated. A young mother named Keisha had been sued by a debt collector over a medical bill she'd already paid. She brought receipts. The judge ruled against her anyway. Clerical matters should be resolved administratively. Each story, the same judge. After the session ended, Harper approached Reverend Okonkwo. "Powerful testimonies," she said. "The patterns are striking." He studied her, recognized something, maybe the quality of her attention, maybe the question she didn't ask. "You're not from here." "No." "But you're interested in Judge Kessler." "Very." He glanced around the emptying room, then back to her. 14 complaints. That's what I know of personally. Helped file half of them myself. His voice dropped. Not one investigation, not one hearing, not even an acknowledgement that they were received. Harper nodded. The system protects its own. "You understand?" He paused. "What's your angle, Ms. Riley? And I'm just a citizen seeking justice." He didn't believe her, but he respected the boundary. "If you're collecting documentation, I can connect you with some of the complainants, the ones willing to talk." "I'd appreciate that." They exchanged contact information. Paper, not phones. Old habits. As Harper walked to her car, she passed the young man who had been leaning against the wall. He fell into step beside her. "You a lawyer?" "No." "Reporter?" "No." He stopped. She turned. "Then why do you care?" Harper looked at him. 23, maybe 24. The age where you still believed exposure led to accountability, where you thought documentation meant anything without power behind it. "Because someone should," she said. He didn't seem satisfied, but he stepped aside. Harper drove back to her hotel through streets she was beginning to recognize, the highway exits, the shopping plazas, the neighborhood lines that invisible forces enforced more effectively than any law. In her room, she opened her laptop, created a new folder. Pattern documentation. Kessler, W. Inside, 47 files, and growing. 2 days later, Harper returned to the courthouse to file supplemental evidence. Her original case file had been misplaced. Patricia Loomis delivered the news without a trace of apology. "These things happen. High-volume court, limited staff. You'll need to refile everything from the beginning. I have copies." Patricia's smile tightened. "Copies need to be certified. Certification office is in the basement. Open 9 to 11 a.m., Tuesdays and Thursdays only. Today's Wednesday." "I was told my hearing is in 12 days, without the original file." "Not my problem, Ms. Riley. I don't set the schedules." Harper didn't argue. She photographed the counter, Patricia's nameplate visible in frame, the wall clock showing the time, the empty slot where her file should have been. "For my records." Patricia's expression flickered. Annoyance. Maybe fear. "Is there a problem?" "No problem." Harper lowered her phone. "I'll return Thursday morning." She did. The certification office was open. Her copies were certified. Her file was reconstituted. But she had lost 4 days, and the hearing date remained unchanged. System friction, designed to exhaust. The motion arrived on day 8. Victor Stahl had filed for sanctions, claiming Harper's discovery requests were frivolous, burdensome, and harassing in nature. The document was 12 pages long, filled with procedural citations and indignant language. Plaintiff, proceeding pro se, has demonstrated a pattern of vexatious litigation tactics designed to intimidate the defendant and abuse the court's limited resources. Her excessive document requests, including demands for 10 years of inspection records and communications with all former tenants, far exceed the scope of a simple security deposit dispute. The motion requested $4,500 in attorney's fees, nearly double the original claim. Harper read it 3 times, then opened a new document. Her opposition was filed that same evening, 9 pages, single-spaced. She documented every request she had made and showed that each one mirrored requests the defendant had served on her, line by line, identical in scope. She cited case law showing that sanctions required a finding of bad faith, not mere disagreement over discovery parameters. She included a table comparing her document requests to industry-standard discovery in landlord-tenant disputes, demonstrating that her approach was, if anything, conservative. And she attached an appendix, a summary of the 14 prior complaints against Judge Kessler, noting that multiple complainants had alleged selective application of procedural rules. That last part was a gamble, possibly improper, definitely provocative, but she wanted it on the record. The sanctions hearing was scheduled for 10 days later. Same courtroom, same judge. Harper arrived at 1:15, same seat, same posture, same leather portfolio. Judge Kessler entered at 1:28, but something was different today. His expression was tighter, his movements more deliberate. He had read her opposition. He knew what she had attached. Case 2024-SC-08847, motion for sanctions filed by defendant Cornerstone Property Management. He didn't look at her. Mr. Stahl, your motion. Victor Stahl rose, his usual confidence slightly muted. Your Honor, the defendant seeks sanctions under Rule 11 for frivolous discovery abuse. Ms. Riley's requests. I've read the motion. Kessler's voice was flat. I've also read the opposition, including the appendix. Silence. Ms. Riley. Now he looked at her. You attached material relating to prior judicial complaints to a motion response in a small claims case. Do you understand how inappropriate that is? Harper stood. Your Honor, the material is relevant to the defendant's claim that my litigation tactics are vexatious. I included evidence showing that similar procedural tactics have been documented in other cases, suggesting a pattern that extends beyond my individual conduct. You're accusing this court of bias. I'm providing context. Context. Kessler's jaw worked. Let me be clear about something, Ms. Riley. This is my courtroom. In my courtroom, we follow the rules, and the rules do not include ambushing the bench with irrelevant accusations disguised as legal argument. The material is relevant to. The motion for sanctions is denied. He cut her off, voice rising. Not because your conduct wasn't troubling, it was, but because Mr. Stahl hasn't met the technical threshold for monetary penalties under Rule 37. Victor Stahl's face showed nothing. Kessler continued. However, I am placing you on notice, Ms. Riley. Any further conduct that this court deems frivolous, harassing, or disrespectful will result in immediate sanctions, up to and including contempt. Do I make myself clear? Perfectly, Your Honor. Good. He slammed his gavel. We're adjourned. The courtroom emptied. Harper remained seated, writing in her notebook. 3 words. Retaliation threat. Recorded. The transcript would be interesting when it finally arrived. That night, Harper met with 3 former litigants from Reverend Okonkwo's network. They gathered at a coffee shop in Noda, neutral ground, public space. Their stories filled in the gaps. A man named Terrence had sued his employer for unpaid wages. Judge Kessler dismissed the case because Terrence's timesheets were hearsay, even though the employer had signed them. A woman named Jacqueline had sought a restraining order against her stalker ex-boyfriend. The judge denied it, finding insufficient evidence of imminent threat. 2 weeks later, the boyfriend broke into her apartment. She still had the scars. A teacher named Marcus had fought a wrongful termination claim. His evidence was solid: emails showing racial animus, performance reviews that contradicted the stated reasons for his firing. The judge ruled against him anyway. Insufficient documentation of discriminatory intent. Harper listened. Recorded with permission. Documented. The pattern wasn't subtle, wasn't hidden, wasn't even particularly careful. It was simply protected. "What happens now?" Terrence asked. "You collect these stories, write a report. And what? The same people who ignored the complaints ignore your report too?" "Maybe," Harper admitted. "Maybe not. Depends on who reads it." "And who's going to read it?" She didn't answer. The next 2 weeks brought more friction. Harper's motion for expedited scheduling was denied. Her request for transcript copies was delayed. Backlog of 6 to 8 weeks. Her supplemental exhibits were lost twice before finally being logged into the system. Each obstacle documented, each delay recorded, each timestamp preserved. The system didn't need to defeat her, it just needed to exhaust her. But Harper Riley didn't exhaust easily. The final hearing was scheduled for a Thursday afternoon. Case 2024-SC-08847, now nearly 3 months old. Harper arrived early, sat in the gallery, watched the cases before hers. A white plaintiff won a contract dispute in 8 minutes. His documents were clearly authenticated. His testimony was credible and persuasive. An elderly black woman lost a medical debt case. Her receipts were insufficient. Her payment records were ambiguous. The pattern held. When Harper's name was finally called, she approached the podium with her portfolio open. "Ms. Riley, still representing yourself." Kessler's tone dripped condescension. "Are we ready to proceed, or do you have more appendices to share?" "I'm ready, Your Honor." "Then let's get this over with." The hearing proceeded like the others. Harper presented her evidence. Stahl objected. Some objections were sustained, others overruled. But the rhythm was predictable. The outcome already decided. Until the moment when it wasn't. Harper was presenting her final exhibit, a comparative timeline showing the landlord's changing justifications for withholding the deposit. When Kessler interrupted, "Ms. Riley, I'm going to stop you there." He shuffled papers. "You've now spent 47 minutes presenting what amounts to a he-said-she-said dispute over a carpet stain. Do you have anything approaching actual evidence, or are we just going to keep doing this?" His gesture encompassed her, all of her. Harper's voice didn't waver. "Your Honor, I have documented evidence of the apartment's condition on move-out, the landlord's acknowledgement of that condition in writing, and the subsequent wrongful retention of—" "I'm sorry, could you repeat that?" Kessler leaned forward, expression theatrical. "And this time, maybe try speaking proper English. This is a court of law, not a whatever it is you're used to." The words landed like stones in still water. Scattered laughter from the gallery. The bailiff's smirk, now familiar. The court reporter's fingers pausing, just for a moment, over the keys. Harper didn't flinch. Didn't react. Didn't give him anything. Instead, she closed her portfolio, opened a different folder. "Your Honor, before you rule, I'd like to introduce myself properly." Kessler's eyebrows rose. "I know who you are, Ms. Riley. We've been through this quite extensively. My name is Harper Riley." She met his eyes. "I serve as Senior Advisor for Judicial Nominations in the White House Counsel's office." The silence that followed was absolute. Every head in the courtroom turned. The bailiff's smirk vanished. Victor Stahl's folder slipped from his fingers, papers scattering across the table. Judge Kessler's face drained of color. "3 months ago," Harper continued, "your name was submitted for consideration to the Fourth Circuit Court of Appeals. I was assigned to conduct informal background observation." She placed a document on the podium. "This is a preliminary assessment report I prepared for the White House Counsel regarding your nomination." Kessler's mouth opened, closed. No words came. The report documents conduct I have personally witnessed in this courtroom over the past several weeks. It also incorporates information from 14 prior complaints that were dismissed without investigation by the Judicial Standards Commission. She produced 3 envelopes, each labeled. Copies of this report, along with supporting documentation, were sent by certified mail this morning to the North Carolina Judicial Standards Commission, the Department of Justice Civil Rights Division, and the Senate Judiciary Committee. Receipt confirmations are included. She laid the envelopes on the plaintiff's table, one by one. The assessment recommends immediate withdrawal of your nomination pending formal review. Victor Stahl found his voice. Your Honor, my client would like to request a brief recess to discuss settlement options. Kessler turned on him. Settlement? Settlement? Do you understand what's happening here? I believe I do, Your Honor. Stahl was already gathering his scattered papers, avoiding the judge's eyes. And I'm advising my client that continued litigation in this matter may not be in their best interest. 18 years of Thursday golf games, erased in 90 seconds. Harper collected her documents. Didn't rush. Didn't gloat. The court will have a copy of the report within 48 hours. I trust you'll want to prepare a response. She walked toward the exit, every eye in the courtroom following. At the door, she paused, turned. For the record, Your Honor, my English has always been proper, but you wouldn't know that. You never listened long enough to find out. The door closed behind her. In the hallway, Harper's hands finally trembled, just slightly, just for a moment. She reached for her phone, dialed a number saved under a 2-letter abbreviation. It connected on the second ring. Harper, I received your package. And? The nomination is being withdrawn, quietly, personal reasons. A pause. But that's not enough, is it? No, it's not. Didn't think so. DOJ is opening a preliminary inquiry, pattern or practice, under 34 U.S.C., paragraph 12,601. The documentation you provided gives them grounds to proceed. Harper closed her eyes, drew a breath. What about the commission? Slower. You know how state processes work, but you've created a record they can't ignore. Not anymore. He's still on the bench. For now. These things take time, Harper. Months, sometimes years. You know that. She did know. That was the worst part. You did good work, the voice continued. The messy kind, the kind that matters. Come home when you're ready. The call ended. Harper stared at the courthouse doors, the marble columns, the carved words above the entrance. Justice under law. 3 months of her life. 14 complaints, finally heard. 1 nomination, destroyed. And somewhere inside that building, Judge Warren Kessler still sat on the bench, still wore the robes, still had the power to ruin lives with a gavel and a sneer. The work wasn't done. It was barely begun. This is just the beginning. In Part 2, the DOJ investigation uncovers something far worse than bias, and Harper discovers that Kessler was protected by people who knew exactly what he was doing. Subscribe now so you don't miss what happens next. Harper walked to her rental car in the courthouse garage. Same flickering light, same empty rows. No footsteps followed her this time. But as she reached her vehicle, she noticed something on the windshield. A folded piece of paper tucked under the wiper blade. She unfolded it. 5 words, printed in block letters. The 2016 Backlog Purge. No signature, no explanation. Harper photographed the note, then photographed the garage around her, the cameras, the exit signs, the empty spaces. Someone inside the system wanted her to keep digging. And somewhere in the records, buried, redacted, or destroyed, was a thread that led somewhere she hadn't yet imagined. The 2016 Backlog Purge. She'd never heard of it, but she would find out. She folded the note carefully, placed it in her portfolio, and drove away. The lock clicks twice, then silence. The note sat on Harper's hotel desk for 3 hours before she touched it again. The 2016 Backlog Purge. 5 words. Block letters. No fingerprints visible. She'd checked with the flashlight on her phone, angling the paper against the light. Whoever left it knew what they were doing. Harper opened her laptop, searched the North Carolina court system database for any reference to 2016 in Backlog. Nothing relevant. Searched news archives. A few mentions of budget constraints, staffing shortages, the usual bureaucratic complaints. Nothing about a purge. She tried the Judicial Standards Commission website. Annual reports going back to 2010. The 2016 report was notably thin, 12 pages compared to the usual 25. No explanation for the brevity. No mention of any special procedures or administrative changes. But in the appendix, buried in a footnote, she found something. Pursuant to Administrative Order 2016, JC-07, the Commission implemented revised record retention protocols effective March 1, 2016. Historical complaint files predating 2012 were transitioned to off-site storage. Files deemed administratively resolved were processed according to updated guidelines. Administratively resolved, processed, transitioned. Bureaucratic language for destroyed. Harper leaned back in her chair, stared at the ceiling. If complaint files had been purged in 2016, that meant the 14 complaints she knew about, the ones Reverend Okonkwo had helped file, were only the survivors. The ones filed after the purge. The ones that couldn't be erased because they were too recent. How many complaints had existed before 2012? How many had been processed into oblivion? And who had ordered it? Her phone buzzed. Text message from a blocked number. Records request. Case 2016-JC-07. Ask for the dissent. Harper screenshot the message, then deleted the original. Someone inside the system was feeding her breadcrumbs. Someone who knew what had been buried and wanted it found. The question was, why now? And why her? The next morning, Harper drove to Raleigh. The North Carolina Judicial Standards Commission occupied the 3rd floor of a nondescript government building on Fayetteville Street. Security was minimal, a sign-in sheet, a board guard, an elevator that groaned between floors. The records office was smaller than she expected. 2 clerks behind a counter, filing cabinets lining the walls, a smell of old paper and older coffee. I'd like to request documents related to Administrative Order 2016 JC-07. The clerk, a young woman with tired eyes and a name tag reading Denise, looked up from her computer. That's an internal administrative order, not subject to public records requests. The order itself may be internal, but its effects aren't. I'm requesting any publicly available documentation regarding the 2016 record retention changes, meeting minutes, public notices, anything filed in the normal course of business. Denise hesitated, glanced at her colleague, an older man who hadn't looked up from his newspaper. I'll need to check with my supervisor. I'll wait. 20 minutes passed, then 40. Harper sat in one of the plastic chairs along the wall, reviewing her notes, projecting patience she didn't feel. Finally, Denise returned with a thin folder. This is what we have available. Meeting minutes from March 2016. The order itself is referenced but not included. There's also... She hesitated. There's a notation about a dissenting opinion, but the opinion itself is sealed. Sealed under what authority? I don't know. It just says, sealed by commission vote, 4-1. 4-1. Someone had objected. Someone had tried to stop it. Who cast the dissenting vote? Denise shook her head. That information isn't in the public record. Harper took the folder, signed the receipt, walked back to her car. In the parking garage, she opened the folder and read. The meeting minutes were sparse. Procedural language, vote tallies, no discussion recorded. But in the margins, handwritten, barely legible, someone had scrawled 2 words. Mercer objected. Harper photographed the page, then searched her phone for the name. Judge Annette Mercer, retired from the commission in 2017, former appellate judge, currently living in Asheville, 2 hours and 47 minutes away. Harper started the car. If you're watching this far, you already know this story is different. Subscribe and hit the bell. Part 2 is just getting started. Asheville in late autumn carried a different weight than Charlotte. The mountains pressed close, their edges softened by mist. The air smelled of wood smoke and decay. Judge Annette Mercer lived in a craftsman bungalow on a quiet street near the university. The yard was immaculate, late-season flowers still blooming, leaves raked into precise piles. A woman who valued order. Harper parked across the street, sat for a moment, considered her approach. Cold calls rarely worked. Retired officials had no obligation to speak, and most preferred silence. But sometimes, if you caught them at the right moment, with the right question, the weight of what they knew became heavier than the comfort of keeping it buried. She walked up the flagstone path, knocked. The woman who answered was smaller than Harper expected. Late 70s, silver hair cropped short, eyes sharp behind rimless glasses. She wore gardening gloves and an expression of cautious assessment. "Judge Mercer?" "Former judge. Who's asking?" "My name is Harper Riley. I work for the White House Counsel's office. I'm investigating a matter involving the North Carolina Judicial Standards Commission, specifically an administrative order from 2016 regarding record retention." Mercer's expression didn't change, but something shifted behind her eyes. "You'd better come inside." The living room was filled with books, legal texts, histories, biographies of judges Harper recognized and some she didn't. On the mantel, a photograph, a younger Mercer in judicial robes standing beside two colleagues. One of them was Warren Kessler, Harper noticed. Filed it away. "Tea? Coffee?" "Whatever you're having is fine." Mercer disappeared into the kitchen, returned with 2 cups of chamomile, steam rising. "So," she settled into an armchair across from Harper. "Someone finally came asking about 2016. You were expecting someone?" "Hoping, maybe, though I'd given up." She sipped her tea. "How much do you know?" "I know there was an administrative order that changed record retention policies. I know complaint files were purged, destroyed, essentially. I know you voted against it." "I did." Mercer set down her cup. "And I was the only one." "Why?" "Because I knew what it meant, what it was designed to do." She paused. "Do you know how many complaints were filed against Warren Kessler before 2012? Harper shook her head. 43. The number hit like a physical blow. 43 complaints, spanning almost a decade. Some were minor, tone, demeanor, procedural shortcuts, but others. Mercer's voice hardened. Others documented a pattern that should have ended his career before it properly began. What happened to those complaints? What do you think? They were investigated, if you can call it that. Staff reviews, closed sessions, findings of insufficient evidence or no actionable misconduct. The same language over and over, copy and paste, file and forget. But the files existed. They existed until 2016, when the Commission decided that maintaining historical records was administratively burdensome and inconsistent with modern document management practices. Mercer's laugh was bitter. The resolution passed 4-1. I wrote a dissent, 16 pages, documented every complaint that would be destroyed, every pattern that would be erased. They sealed it. On what grounds? Confidentiality of complainant information. A convenient excuse. She met Harper's eyes. The real reason was simpler. Warren Kessler was being discussed for federal appointment even then. His file was the thickest in the archive. His patterns the most documented. If anyone ever looked, really looked, at what was in those records, they cleaned house. They burned the evidence. And I was the only one who objected. Mercer picked up her tea again. I retired the following year. I couldn't be part of that institution anymore, knowing what I knew, what I'd failed to stop. Harper let the silence sit. Then, I have 14 complaints documented, filed after 2016. 14. Mercer nodded slowly. So it continued. It never stopped. No, I suppose it wouldn't have. She looked toward the window. The mist was thickening, the mountains disappearing into gray. What are you going to do with this information, Ms. Riley? Document it. Submit it to DOJ. Make sure the pattern can't be erased again. And Warren? His federal nomination has already been withdrawn. The state commission is opening a formal hearing. Mercer was quiet for a long moment. A hearing. After 40 years. 57 complaints, if we're counting the ones I know about. She shook her head. He'll get a reprimand, maybe a suspension. He'll keep his pension, his legacy, his friends. Probably. And you think that's justice? Harper considered the question, really considered it. No, I think it's accountability. Partial, delayed, incomplete, but documented, on the record. Impossible to bury this time. She paused. It's not enough, but it's more than anyone else managed. Mercer studied her for a long moment, then nodded. You're not what I expected. What did you expect? Someone younger, more naive, someone who still believed the system could be fixed from within. A small smile. You don't believe that, do you? I believe the system can be documented, exposed, made to answer for itself, even if it doesn't change. Harper set down her cup. Sometimes documentation is all we have. And sometimes it's enough to shift the ground, just slightly, just enough for the next person to stand on. They sat in silence as the mist swallowed the mountains entirely. Before Harper left, Mercer handed her a flash drive. My files. Everything I saved before I retired. The complaints I could access. The patterns I documented. Names, dates, case numbers. She pressed it into Harper's palm. I kept copies. Against all regulations. Against my own better judgment. But I knew someone would come asking eventually. Why didn't you go public yourself? I was one retired judge against an entire system. No platform, no protection, no guarantee anyone would believe me. Her eyes met Harper's. You have something I never had. Access, authority, the ability to make them listen. Harper pocketed the drive. Thank you, Judge Mercer. Annette, and don't thank me yet. She walked Harper to the door. Warren has survived worse than this. He has friends, powerful ones, the kind who don't forget when someone threatens their interests. I've been warned. I'm sure you have. But warnings and reality are different things. Mercer opened the door. The mist had turned to drizzle. Be careful, Ms. Riley. The people who protect Warren Kessler don't fight fair. They never have. Harper stepped onto the porch, turned back. Neither do I. The drive back to Charlotte took 3 hours through rain-slicked mountain roads. Harper stopped once, a gas station outside Morganton, to copy the contents of Mercer's flash drive to her laptop and upload an encrypted backup to secure cloud storage. The files confirmed everything. And worse. 43 complaints before 2012. 14 more after 2016. A total of 57 documented instances of judicial misconduct spanning almost 15 years. Racial disparities in rulings, procedural violations, statements on the record that would end any other career in any other profession, and beneath it all, a network of protection. Other judges who handled complaint referrals, attorneys who knew which cases would be decided before arguments were heard, a court system that had internalized bias so deeply it no longer recognized it as bias at all. Harper arrived back at her hotel after midnight, exhausted, wired, unable to sleep. She opened her laptop, began organizing the evidence, creating a timeline, building a case. By 3 a.m., she had a 30-page memorandum. By 5 a.m., she had supporting exhibits. By 7 a.m., she had sent it to the Department of Justice. The response came faster than she expected. 2 days after her submission, Harper received a call from the Civil Rights Division. Special Counsel Adrienne Walsh, career prosecutor, 15 years with DOJ, a reputation for thorough and relentless investigation. Ms. Riley, I've reviewed your materials. Impressive documentation. Thank you. I have questions. Harper spent the next 2 hours on the phone, walking Walsh through the evidence, the complaints, the purge, Judge Mercer's dissent, the patterns that connected everything. Walsh listened without interruption, asked precise, targeted questions, took notes. Harper could hear scratching through the phone. Finally, "This is sufficient to expand our preliminary inquiry. We'll be requesting access to state court records, commission files, and any additional documentation the state is willing to provide. And if they're not willing, then we subpoena." Walsh's tone was matter-of-fact. "We've done this before. States don't like federal oversight, but when the evidence is this clear, they don't have much choice." "What's the timeline?" "These things move slowly, you know that. Formal investigation, evidence gathering, interviews, analysis. If we find what I suspect we'll find, we issue a findings letter. Then we negotiate reforms, or we litigate." "Years?" "Possibly. But the process has begun. And unlike the State Commission, we don't seal our dissents or purge our files." A pause. "You did good work, Ms. Riley. The kind that creates a foundation. Now let us build on it." The call ended. Harper stared at her phone. Years. The word sat heavy in her chest. But the process had begun. For the first time in decades, someone with actual authority was asking actual questions. Someone who couldn't be pressured by golf games or donor relationships or Thursday afternoon favors. It wasn't victory, but it was momentum. The North Carolina Judicial Standards Commission hearing was scheduled for 8 weeks after the DOJ inquiry began. Harper flew back to Charlotte for it. She wasn't required to attend. Her sworn statement had been submitted in writing, but she wanted to be there, needed to see it through. The hearing room was smaller than she expected. Wood paneling, American flag, 5 commissioners seated at a raised table. The kind of room where careers ended quietly, without witnesses. Today, there were witnesses. Media had been alerted, not by Harper, but by the growing attention the case had received. 3 reporters occupied the back row. A court sketch artist captured the scene in charcoal. Judge Warren Kessler sat at the respondent's table with his attorney, a silver-haired man named Carlton Webb, who specialized in defending judges against misconduct allegations. Webb's record was impressive. 15 cases, 15 dismissals, or minimal sanctions. He knew how to work this room. Harper sat in the gallery, 4th row, left side. She wore the same modest blazer she'd worn in Kessler's courtroom, a small reminder of where this had begun. The commission chair, a stern woman named Commissioner Elaine Wade, called the hearing to order. This commission has convened to address formal complaints against Judge Warren Kessler of the 4th Judicial District. The complaints allege conduct prejudicial to the administration of justice, including but not limited to discriminatory treatment of litigants, procedural irregularities, and statements on the record that may violate Canon 3 of the North Carolina Code of Judicial Conduct. She paused, adjusted her glasses. The commission has received 23 formal complaints regarding Judge Kessler, spanning a period of 11 years. Previously, all complaints were resolved through administrative review without formal hearing. In light of evidence submitted by the Department of Justice and corroborated by multiple witnesses, this commission has determined that a formal hearing is warranted. Kessler's expression remained neutral, but Harper caught the slight tightening around his eyes. The controlled stillness of a man who had never expected to be here. The investigator presented findings first. A young attorney from the commission's staff, nervously shuffling papers as she walked the commissioners through the evidence. The investigation reviewed 847 small claims cases presided over by Judge Kessler between 2018 and 2024. Statistical analysis reveals significant disparities in outcomes based on litigant demographics. She clicked a slide, Numbers appeared on the screen. Black plaintiffs prevailed in 23% of cases. White plaintiffs prevailed in 71%. When controlling for case type, evidence quality, and representation status, the disparity remained statistically significant at p-value less than 0.001. The numbers hung in the air, stark, undeniable. Additionally, transcript review identified multiple instances of on-the-record statements that appear to violate standards of judicial demeanor. Exhibit 7 in your packets contains selected examples. The commissioners turned pages. Harper watched their faces. Some remained impassive. One, a younger man on the left, visibly flinched. Among the statements documented, maybe try speaking proper English. Don't lecture me on the rules of evidence. The legal standard is whatever I say it is. These statements, in context, suggest a pattern of dismissive treatment toward pro se litigants, particularly those of color. Carlton Webb rose smoothly. Commissioner Wade, my client maintains that these statistics and statements taken out of context do not represent the totality of his 18 years of distinguished service. Individual case outcomes reflect the merits presented, not judicial bias. And statements made in the heat of courtroom proceedings, while perhaps inartfully phrased, do not constitute misconduct. Mr. Webb, you'll have full opportunity to present your response. Please be seated. Webb sat. His expression suggested this was exactly what he expected, a process to be endured, not a battle to be won or lost. The hearing continued for 3 hours. Witnesses testified, former litigants describing their experiences, court staff offering carefully worded observations, an expert in judicial conduct providing context for the statistical findings. Through it all, Kessler said nothing. His attorney objected occasionally, made technical arguments about evidence admissibility, reminded the commission of proper procedure. But the judge himself remained silent, watching the proceedings with an expression of detached patience, as if this were merely a formality. A temporary inconvenience before normal service resumed. Harper recognized that expression. She'd seen it in every courtroom where he'd presided. The certainty of a man who had never faced real consequences, who didn't believe they were possible. The commission broke for deliberation at 4:15 p.m. Harper remained in her seat as others filed out. She wasn't sure what she was waiting for. Some indication that this would be different, that the hours of testimony had shifted something. But the room felt the same. The flag hung motionless. The wood paneling absorbed sound without echo. Carlton Webb approached her on his way out. "Ms. Riley?" She didn't respond. "Quite an effort you've mounted here. Very thorough, very persistent." He smiled, the professional smile of a man who separated personal feelings from professional outcomes. "For what it's worth, I've advised my client to accept whatever sanctions the commission imposes. No appeals, no further proceedings. A quiet resolution." A quiet resolution. Harper's voice was flat. "That's what he's always had, isn't it?" Judge Kessler has served this state for nearly 2 decades. His record is 57 complaints and 0 accountability, until now. Webb's smile didn't waver. "Accountability is relative, Ms. Riley. A reprimand, perhaps some mandatory training, a shift in docket assignments. These are not insignificant consequences for a man of Judge Kessler's standing. They're also not consequences for the people he harmed, the cases he dismissed, the lives he affected. The law provides specific remedies for judicial misconduct. Emotion, however understandable, doesn't change what those remedies are." He walked away, unhurried, untroubled. Harper remained in her seat. The deliberation took 4 days. Harper returned to Washington in between, meetings, briefings, the ordinary business of government that didn't pause for individual cases. But her phone stayed close. Her email refreshed constantly. On the 4th day, the letter arrived. She was in her office when she opened it. Standard government envelope. Official letterhead. The language precise and bureaucratic. The North Carolina Judicial Standards Commission finds that Judge Warren Kessler engaged in conduct prejudicial to the administration of justice in violation of Canon 3 of the North Carolina Code of Judicial Conduct. The Commission issues a formal public reprimand. Additionally, Judge Kessler is ordered to complete 40 hours of bias awareness training within 12 months, and his docket is reassigned to exclude small claims and pro se matters pending completion of said training. Public reprimand. 40 hours of training. Docket reassignment. For 18 years of documented bias. 57 complaints. Hundreds of affected lives. Harper read the letter 3 times, then set it down. It wasn't enough. It was never going to be enough. But it was more than had ever been imposed before. More than the 43 complaints that had been purged in 2016 had ever achieved. More than the 14 complaints after had accomplished on their own. It was a crack in the wall, not a demolition, just a crack. But cracks spread. We're almost at the end, but trust me, you don't want to miss what happens next. Drop a comment and let me know what you think so far. 3 weeks after the Commission ruling, Victor Stahl's client agreed to settle Harper's original case. The settlement conference took 15 minutes. No posturing, no negotiation, just a single document slid across the table. Full refund of security deposit, $2,340. Payment of filing fees, $96. No admission of wrongdoing. Standard confidentiality clause, waived at Harper's insistence. She signed, collected the check, walked out without ceremony. It had never been about the money. The landlord didn't matter. The apartment didn't matter. What mattered was the record, the documented proof that she had standing, that her claims were legitimate, that everything that followed emerged from a real case with real stakes. The check went into a donation account, local legal aid, the kind of organization that helped people who couldn't help themselves navigate systems designed to exhaust them. Harper didn't need the money, but someone else might need the precedent. The courthouse felt different when she returned to collect her final documents. Patricia Loomis was no longer at the filing window. Her desk sat empty, personal items removed. A younger clerk, new, uncertain, handled Harper's paperwork with nervous efficiency. Ms. Loomis retired last month. Personal reasons. Harper didn't comment, just collected her documents and left. In the hallway, she passed the security checkpoint. Deputy Riggs was also absent. A different officer, older, less aggressive, waved her through without additional screening. Random selection had apparently been discontinued. Small changes, incremental, almost invisible unless you knew what to look for. Harper knew. Reverend Okonkwo called that evening. "I wanted to thank you. What you did, it mattered." Harper sat on the edge of her hotel bed, suitcase open, clothes folded for the flight home. It wasn't enough. No. His voice was heavy but not defeated. But it was more than anyone else ever did. 3 of the families I work with. They're refiling. Cases Kessler dismissed years ago. New judge, new procedures, actual chance at being heard. 3 families. Out of how many? 14 in my network, more beyond that. He paused. Change doesn't come all at once, Ms. Riley. It comes in pieces, small victories that add up. 3 families today, maybe 5 more next year, maybe 10 the year after that. And the ones who can't refile? The cases too old to resurrect? The people who gave up years ago? We remember them. We document what happened. We make sure it doesn't disappear. Another pause. That's what you did. You made sure it couldn't disappear. The files, the patterns, the truth. It's on the record now, permanently. Harper closed her eyes. I hope that's enough. It's a start. Starts are what we have. She flew back to Washington the next morning. Same modest luggage, same rental car return. The Charlotte skyline receded in the airplane window, disappearing into clouds. On her laptop, a new folder. Kessler, W. Closed. Inside, everything. The complaints, the transcripts, the statistical analysis, the commission ruling, the settlement agreement, the anonymous notes about the 2016 purge, A complete record. Preserved. Backed up. Impossible to erase. Harper closed the laptop. Leaned back. Let the engine noise fill her head. It wasn't victory. Victory implied completion, resolution, an ending. This was something else. A pause. A notation in the margin of a much longer story. Judge Warren Kessler was still on the bench. His docket had changed. His reputation had suffered. His federal ambitions were permanently dead. But he still wore the robes, still drew the salary, still carried the title that conveyed authority he had systematically abused. The system had bent. It hadn't broken. But bending was something. Bending meant pressure had been applied, meant the next time might be different, meant the ground had shifted just slightly, just enough for someone else to stand on. Harper's phone buzzed. Email notification. She opened it. DOJ letterhead. Subject line, Preliminary Inquiry, Mecklenburg County Court System. Ms. Riley, this is to inform you that the Civil Rights Division has concluded its preliminary inquiry and will proceed to a formal investigation under 34 U.S.C. Paragraphu Labing Dalawamput Anim Nalibo at Isang. Based on evidence gathered to date, including documentation you provided, we have identified potential pattern or practice violations sufficient to warrant expanded review. A federal monitor may be appointed pending investigation outcomes. State cooperation has been requested and, we anticipate, will be forthcoming. We will keep you apprised of significant developments. Your contributions to this matter have been noted and appreciated. Adrienne Walsh, Special Counsel, Civil Rights Division. Harper read the email twice, then saved it to her records. A federal monitor, expanded investigation, state cooperation, willing or otherwise. The wheels were turning, slowly, bureaucratically, but turning. She closed her eyes again. Let herself feel, just for a moment, something like hope. 2 days later, Harper was back in her office at the White House counsel's suite. Same desk, same view, same stack of nomination files waiting for review. The work continued. It always did. But something had changed. Not in the system. The system was vast and slow and resistant to change. In her, in how she saw the work. Before Charlotte, she had reviewed files with clinical precision. Qualifications, credentials, endorsements, the measurable markers of a judicial career. She had trusted the process, the vetting, the recommendations, the layers of review that were supposed to catch problems before they reached her desk. Now she knew better. Now she knew that some problems weren't caught because they weren't considered problems. That bias could hide behind proper procedure. That 18 years of complaints could disappear with an administrative order and a 4-to-1 vote. The next nomination file sat open in front of her. Different judge, different circuit, different state. She began reading. But this time, she read differently. Not just what the file contained, but what it might be hiding. Her desk phone rang. Internal line. Harper, quick question. It was the chief counsel. Gregory Townsend. Political appointee, well-connected, focused on efficiency and optics. The Kessler file. It's closed, right? The commission issued its ruling. Federal investigation is ongoing. Good, good. A pause that wasn't quite comfortable. Because we're getting some pressure. Some senators want to know who leaked the pattern data. The statistics, the historical complaint numbers. I submitted an official report through proper channels. Everything in that report was documented and sourced. I know. Townsend's voice was careful. But some of the data, the pre-2016 numbers, the purge documentation, that wasn't in your original assignment scope. Questions are being asked about how you accessed sealed commission records. I interviewed a former commission member who had retained personal copies. Not sealed records, personal documentation. Right, and that's technically proper. But the optics of exposing judicial misconduct? The optics of a federal official accessing state records through unofficial channels. Harper let the silence stretch. Is there a problem, Greg? No, no problem. He sounded like a man convincing himself. Just be careful. The Kessler thing touched some nerves. People in North Carolina who thought they were protected. People here who had relationships with those people. You made some folks uncomfortable. That wasn't my intention. No, but it was the result. Another pause. Look, you did good work, solid work, but good work sometimes has consequences. Just watch your back. That's all I'm saying. The call ended. Harper stared at the phone. Watch your back. The same warning Judge Mercer had given. The same message Marcus Henley had delivered in the parking garage, though with different words. The system protected itself, not just in North Carolina, everywhere. She turned back to the nomination file on her desk. Read another 3 pages, made notes, did the work. But the warning sat in the back of her mind, a weight she couldn't quite set down. The anonymous email arrived that evening. Harper was home. A small apartment in Adams Morgan, books stacked on every surface, a single photograph of her parents on the windowsill. She was making dinner, half watching the news, when her phone buzzed. New email, unknown sender, Proton mail address. Subject, R.E. Kessler. Documentation. Ms. Riley, you found 14 complaints. There were more. The others were removed before they reached the commission, not during the 2016 purge. Before, someone was screening them, redirecting them, making sure they never got logged. Ask about the intake coordinator, 2008 to 2014. Her name was Vance. She left suddenly. No forwarding address, no exit interview. The 2016 purge covered the tracks. But the tracks started earlier, much earlier. A friend Harper read it 3 times, then screenshot it, then deleted the original. Vance, intake coordinator, 2008 to 2014. A name she had never encountered. A role that shouldn't have had the power to screen complaints. A gap in the timeline that no one had mentioned. She opened her laptop, began searching. The North Carolina court system employee database was partially public. Staff directories, organizational charts, contact information for current employees, but former employees were harder to trace. After an hour, she found a mention, a 2013 internal newsletter archived on an obscure government subdomain. Staff recognition section. Congratulations to Linda Vance, intake coordinator, on her 10 years of service to the Judicial Standards Commission. Linda Vance. 10 years, which meant she started in 2003 and left in 2014. Suddenly, no forwarding address, no exit interview. Harper cross-referenced. Social Security death records showed nothing. Criminal databases showed nothing. Property records showed a home in Wake County, sold in 2014, buyer's name redacted in the public filing. Linda Vance had disappeared, or been disappeared. Harper leaned back, stared at the ceiling. This was bigger than one judge, bigger than one courthouse, bigger than she had imagined when she checked into that extended stay hotel 3 months ago. Someone had built a system within the system, a filter that ensured certain complaints never reached the people tasked with investigating them. And when that filter became too risky to maintain, they had burned the evidence. The 2016 purge wasn't just about protecting Warren Kessler, it was about protecting the entire apparatus that had protected him. And whoever built that apparatus was still out there, still watching, still protecting their interests. Her phone buzzed again. Same unknown sender. Be careful who you ask about Vance. Some questions have consequences. Harper stared at the message, then closed her laptop. The work wasn't done. It was barely begun. But tonight, she needed to think, to plan, to figure out how to pull on a thread that someone very powerful had spent years trying to bury. She turned off her phone, ate her dinner in silence, watched the lights of the city through her window. Tomorrow, she would start again. The next morning, Harper placed a single call. Secure line. A number she hadn't used in years. "This is Riley." "Harper." The voice on the other end was female, older, carrying the weight of decades in government service. "It's been a while. I need a favor, Margaret." Margaret Chen, no relation to any Chen Harper had ever known, had spent 30 years at the FBI before retiring to consulting, which mostly meant helping people navigate situations that required more than official channels could provide. "I'm listening." "I need to find someone who doesn't want to be found. Former state employee. Disappeared in 2014. Possible relocation under duress." "That's a significant ask." "The person may have information about systematic screening of judicial misconduct complaints, a filter that ensured certain cases never reached investigators." Silence on the line. Then, "Send me what you have. Name, dates, last known location. I'll see what I can find." "Thank you, Margaret." "Don't thank me yet. If this person disappeared for the reasons you're suggesting, there's a reason they stayed hidden. Finding them might put them at risk, and you." "I know." "Do you? Because you're not talking about a single corrupt judge anymore. You're talking about infrastructure. Someone built that. Someone maintained it. Someone decided it was worth protecting." "I know," Harper repeated. "All right, send the file. I'll be in touch." The call ended. Harper composed the email, attached everything she had on Linda Vance, encrypted it, sent it. Then she returned to her day job. The nomination files, the meetings, the ordinary machinery of government that continued regardless of what shadows moved beneath it. But part of her mind stayed in Charlotte, in Asheville, in the anonymous emails and the disappeared intake coordinator and the system that had protected Warren Kessler for nearly 2 decades. The work continued. So did the questions. Margaret called back 3 days later. "I found her." Harper closed her office door, lowered her voice. "Where?" "Montana. Small town outside Helena. Living under her maiden name. Working at a regional hospital. Keeping a very low profile." "Is she willing to talk?" "That's the complicated part. She's scared, Harper. Someone threatened her in 2014, made it very clear that if she ever discussed what she knew, there would be consequences. Not legal consequences. The other kind." "But she talked to you." "She talked to me because I explained who was asking and why, and because she's been waiting 10 years for someone to finally come asking." A pause. "She'll meet you, but not in Montana. Too risky. She suggested neutral ground, somewhere public, somewhere she can disappear if things go wrong." "Where?" "Denver. She has a conference there in 2 weeks. Medical administration. Legitimate cover. She's willing to give you 1 hour." 1 hour. That's what she offered. "Take it or leave it." "I'll take it." Margaret gave her the details. Date, time, location, a coffee shop near the convention center. Linda Vance would be wearing a blue lanyard and carrying a leather messenger bag. "Harper, one more thing." "Yes?" "She asked me to tell you something. A warning, I guess." Margaret's voice was heavy. She said, "They're not judges. The people who threatened me. They're not lawyers. They're not politicians. They're money. That's all. Just money. And money doesn't forget." The call ended. Harper sat in her office, watching the late afternoon light fade over Washington. Money. Not individuals, not institutions. The thing beneath both. The foundation on which power was built and maintained. She had pulled one thread. It led to another and another. And now she was staring at something much larger than a single biased judge in a single courthouse in North Carolina. But she had come too far to stop now. Denver, 2 weeks. She marked her calendar. The flight to Denver was unremarkable. Harper traveled light. Carry-on bag, laptop, Folder of documents she'd reviewed so many times the pages were soft at the edges. The coffee shop was exactly as Margaret had described. Busy enough for anonymity, quiet enough for conversation, exits in 3 directions. Harper arrived 20 minutes early, chose a table with sight lines to all entrances, ordered tea she didn't drink. At exactly 2:15 p.m., Linda Vance walked through the door. She was smaller than Harper expected, mid-50s, graying hair pulled back, the carefully neutral expression of someone who had learned to avoid attention. Blue lanyard around her neck. Leather messenger bag over her shoulder. She spotted Harper immediately, hesitated for just a moment, then crossed the room. "Ms. Riley." "Ms. Vance. Thank you for meeting me." Linda sat, didn't order anything, kept her bag close. "I have 45 minutes. My panel starts at 3. "Then I won't waste your time." Harper opened her folder. "You worked as intake coordinator for the North Carolina Judicial Standards Commission from 2003 to 2014. During that time, you would have been responsible for receiving and logging complaints against state judges." "That was my job, yes." "In 2014 you left suddenly. No notice, no exit interview. You relocated out of state and changed your name." Linda's expression didn't change, but her hands tightened on the strap of her bag. "I had personal reasons." "Ms. Vance, Linda, I know you were threatened. I know someone made it clear that your safety depended on your silence. I'm not asking you to put yourself at risk." Harper leaned forward. "But I need to understand what you saw, what you know." 57 complaints were filed against Warren Kessler over 15 years. 43 of them disappeared in a purge in 2016. But someone told me that complaints were being screened before that, redirected, prevented from ever being logged. Silence. Was that true? Linda looked at her hands, at the table, at the door. Yes. The word was barely audible. Yes, it was true. Not for Kessler specifically. For certain judges. The ones who had protection. What kind of protection? The kind that came with phone calls, from numbers I didn't recognize, telling me which complaints should be flagged for additional review before logging, which ones should be held pending verification, which ones should be lost. Who made those calls? I don't know. The numbers were always blocked, the voices were always different, but the instructions were consistent. Specific judges, specific treatment, a system. Harper processed this. How many judges? 7 that I knew of, maybe more. Kessler was one, but not the only one. Do you have names? Documentation? Linda shook her head. I didn't keep records. I was too afraid. And after I left, she stopped, took a breath. After I left, I just wanted to disappear, to forget. What happened in 2014? What made you leave? The silence stretched longer this time. My daughter. Harper waited. She was 17, had just gotten her license. She was driving home from a friend's house when a car ran her off the road. No witnesses, no cameras. The other driver was never identified. Linda's voice was steady, the kind of steady that came from telling a story too many times in one's own head. She survived, but she was in the hospital for 3 months, and while she was there, I received a phone call. A voice I didn't recognize. Very calm, very polite. It said, "Your daughter was lucky. Accidents happen, but they don't have to." Harper felt cold. They threatened your daughter. They told me exactly what would happen if I ever discussed my work at the commission. What hospital she'd be in, what room, how easy it would be for someone to walk in and finish what the accident started. Linda met Harper's eyes. I resigned the next day, left the state a week later, changed our names, built a new life, and I have spent 10 years waiting for someone to find me. Why didn't you go to the authorities? What authorities? The commission was the authority. The police in Raleigh were cooperative with certain interests. The FBI was federal. They had no jurisdiction over state judicial matters. Who was I supposed to call? Harper had no answer. "I'm sorry," she said finally. "For what happened to you, to your daughter. She's alive. She walks with a limp, but she's alive. She has a family now, 2 children. She doesn't know why we really moved, doesn't know about any of this." Linda's voice hardened. "And she never will. Not because of me." "I understand." "Do you?" Linda leaned forward. "Because what you're doing, poking at this, asking questions, pulling on threads, it has consequences. Not just for you. For everyone connected to you. Everyone you care about. That's how they work. They don't come for you directly. They come for the people you love. I know the risks. You know the concept. That's different from knowing the reality." Linda checked her watch. "I have to go. My panel." She started to rise. "Wait." Harper reached into her folder, pulled out a photograph. "Do you recognize this man?" The photograph showed a figure captured by a courthouse security camera in 2015. Male, well-dressed, face partially obscured. Margaret had pulled it from archived footage, part of a broader sweep she'd conducted while searching for Vance. Linda looked at the image. Her face went pale. "Where did you get this?" "Does it matter?" "He was at the hospital, after my daughter's accident. I saw him in the hallway outside her room, just standing there, watching." "Do you know who he is?" Linda shook her head. "No, but I remember his face. I've seen it in my nightmares for 10 years. She stood, gathered her bag. "Be careful, Ms. Riley. You're not just fighting one judge, you're fighting an entire infrastructure. And the people who built it don't lose." She walked out of the coffee shop without looking back. Harper sat alone with her cold tea and the photograph of a man whose name she didn't know. But she would find out. The flight back to Washington gave Harper time to think. 7 judges, not one. A coordinated system of protection spanning at least a decade. Phone calls from blocked numbers. Threats that turned into action. An infrastructure designed to ensure certain people were never held accountable. And somewhere behind it all, money. That's what Linda had said. Not judges, not politicians, money. The question was, whose money? And what did they get in return? Harper made a list. The 7 judges Linda had mentioned. She needed names. The blocked phone calls, traceable if you knew the right people. The man in the photograph, identifiable with enough digging. But this was beyond her scope, beyond her authority, beyond what she could do alone. She needed help, real help, the kind that came with badges and subpoenas and the ability to compel testimony. The DOJ investigation was ongoing, but it was focused on Mecklenburg County, on Warren Kessler, on the specific patterns of bias that could be documented and proven. This was something else, something larger, something that might implicate people far more powerful than a single state court judge. Harper opened her laptop, began composing an email to Adrienne Walsh, then stopped. If the infrastructure was as sophisticated as Linda suggested, it had tentacles everywhere. Government, law enforcement, maybe even federal agencies. How could she know who was safe to trust? She deleted the draft, closed the laptop. For now, she would work alone, document what she could, build the case piece by piece, and when she had enough, when the evidence was overwhelming, she would find someone she could trust. Until then, silence was survival. The next 3 weeks were a blur of parallel tracks. By day, Harper continued her official work. Nomination files, vetting reports, meetings with senators and judicial candidates, and the endless machinery of federal appointments. She smiled when expected, asked the right questions, played the role she had perfected over years. By night, she investigated. Margaret Chen proved invaluable. Her network extended into corners of government Harper had never known existed, archives that weren't officially archived, records that weren't supposed to be kept, the shadow infrastructure of bureaucracy, the places where information gathered and was preserved by people who understood that paper trails mattered. The man in the photograph remained elusive. Facial recognition software produced no matches in any database Margaret could access. He appeared in 3 other security camera captures, always at the edge of frame, always in the vicinity of courthouse buildings or government offices, always watching. A ghost. Visible but unnamed. The 7 judges Linda had mentioned were harder to confirm. Without documentation, without records, all Harper had was Linda's word. She searched for patterns, judges with unusually clean complaint histories, judges whose careers had advanced despite red flags, judges who had ruled consistently in favor of particular interests. A picture began to emerge. Real estate development, zoning decisions, environmental permits, cases where significant money was at stake, and where judicial outcomes could mean the difference between millions in profits and regulatory collapse. These weren't criminal cases. They were civil matters, administrative decisions, the kind of cases that rarely made headlines but determined how cities were built, who prospered and who lost. And someone had built a system to ensure those cases always went the right way. The connection to Warren Kessler became clearer. His bias against pro-C litigants, particularly those of color, wasn't random. Many of those litigants were challenging housing discrimination, unfair evictions, predatory lending, cases that threatened property interests, cases that were easier to dismiss if the plaintiff was discredited before they even spoke. Kessler wasn't just biased. He was useful, and the people who found him useful had protected him for 18 years. The breakthrough came on a Tuesday evening. Harper was reviewing old commission records, documents Margaret had obtained through methods she didn't ask about, when she found a memo from 2009. Routine correspondence, budget allocations for the upcoming fiscal year. But buried in the appendix was a donor list, annual contributions to the Commission's Judicial Education Fund, a nonprofit that provided training and professional development for state judges. One name stood out: Meridian Properties, LLC. Harper cross-referenced. Meridian Properties was a development company with holdings across 3 states: real estate, commercial construction, multifamily housing, and in 2011, Meridian had been the defendant in a major environmental lawsuit. The case was assigned to Judge Warren Kessler. Plaintiff claimed contaminated runoff from a Meridian development had poisoned local groundwater. Expert witnesses, documentary evidence, a case that should have been strong. Kessler dismissed it on summary judgment. Insufficient evidence of causation. The plaintiff's attorney filed a complaint with the Judicial Standards Commission. It was never logged. Linda Vance's last year on the job was 2014. 3 years after that case was dismissed. Harper dug deeper. Meridian's board of directors, investment partners, legal counsel. One name appeared repeatedly: Carlton Webb, the attorney who had represented Kessler at the commission hearing, the silver-haired man with the 15-0 record defending judges against misconduct allegations. Carlton Webb was Meridian's primary outside counsel, had been since 2004. The pieces clicked together. Webb represented judges accused of misconduct. Webb represented the company that benefited from those judges' rulings, and somewhere in the middle, an infrastructure existed to ensure complaints against those judges never reached the people who might investigate them. It was elegant, almost invisible, a system that protected itself at every level. And now Harper was inside it. Her phone buzzed. Unknown number. She answered. "Miss Riley?" The voice was male, cultivated, polished. "I think we need to talk." "Who is this?" "Someone who's been watching your investigation with interest. Someone who believes you've reached a point where continued pursuit would be unwise." Harper said nothing. "You've accomplished quite a lot. The Kessler nomination, dead. The commission ruling, precedent setting. The DOJ investigation, ongoing. You should be proud. Many people would stop there. Declare victory. Move on." "But I'm not going to do that." "No, I didn't think you would. You've been asking questions about 2009, about a company that was involved in litigation, about connections that certain people would prefer remained undiscovered. Are you threatening me? Threatening is such an ugly word. I'm offering perspective. You've already won, Ms. Riley. You've accomplished more than anyone before you. But there are limits to what can be exposed. Lines that, when crossed, create complications for everyone. Including you? A pause, almost appreciative. You're very direct. I respect that. It's a quality that serves you well. The voice shifted slightly, harder. But directness has consequences. Your parents retired to Florida last year. Lovely home in Sarasota. They must be very proud of their daughter's career. Harper felt ice in her veins. If you touch them, I don't touch anyone. I observe. I advise. I ensure that situations remain manageable. Your parents are safe. They'll remain safe. As long as you understand that some investigations reach natural conclusions, some questions are better left unasked. And if I keep asking, then you make choices that have consequences, consequences that extend beyond yourself, beyond your career, beyond the people you care about. A pause. Think about it, Ms. Riley. You've already changed more than anyone expected. That's legacy enough. The call ended. Harper stared at her phone. Her hands were shaking. She had known this was dangerous. Had understood, intellectually, that she was threatening powerful interests. But hearing her parents' address spoken by a voice that clearly knew everything about her, that made it real in a way nothing else had. She could stop now. Document what she had. Pass it to the DOJ. Let the federal investigation proceed at its own pace. Declare victory and walk away. Or she could keep going. Keep pushing. Keep pulling on threads until the entire tapestry unraveled. One choice was safe. The other was right. Harper sat in the darkness of her apartment for a long time, thinking about Linda Vance's daughter, run off the road by a car that was never identified, about Judge Mercer's 16-page dissent, sealed away where no one would read it, about the 57 complaints and the hundreds of lives affected, and the system that had protected itself for decades. She thought about her parents, about the phone call they might receive, about the accident that might happen if she didn't stop. And she thought about what it would mean to live the rest of her life knowing she could have done something and chose not to. The choice was never really in doubt. Harper picked up her phone, dialed a number she had memorized but never used. Organized Crime and Corruption Unit. This is Harper Riley. I work for the White House Counsel's office. I need to speak with whoever handles public corruption cases involving coordinated judicial misconduct. Please hold. She waited. Music played. The hold stretched. Then a voice, male, tired, skeptical. This is Special Agent Torres. How can I help you? Harper took a breath. I have evidence of a multi-state conspiracy to protect corrupt judges from accountability. The conspiracy involves coordinated witness intimidation, destruction of evidence, and possible involvement of organized financial interests. Silence. That's a significant claim. I have documentation, witness statements, communications records. I've been investigating this for several months, but I've reached a point where continuing alone puts people at risk. My people. Which means this needs to be a federal matter, officially. Where are you located? Washington, but the conspiracy center's in North Carolina. Another pause. Ms. Riley, I should tell you, these cases are complicated, even with evidence. They take years to build, and they don't always end the way you hope. I know. Do you? Because I've seen people like you before, idealists. They think documentation equals accountability, think exposure equals justice. Then they hit the wall, the politics, the plea deals, the protected witnesses who can't be compelled to testify, and they burn out, or worse. I know the risks. You know the concept. That's not the same thing. Harper almost smiled. Linda Vance had said almost exactly the same words. Agent Torres, I don't expect justice. I expect documentation. a record that can't be erased or sealed or purged. If that's all this achieves, a permanent record of what happened, that's something. It's more than exists now. Silence. Then something that might have been respect. All right, Ms. Riley, let's meet. Tomorrow, my office, and bring everything you have. I will. One more thing. Yes? Watch your back. If you've stirred up what I think you've stirred up, you're not the only one who will be watching. The call ended. Harper sat in the darkness, waited for her heart to stop racing. Then she opened her laptop, began organizing everything she had. The complaints, the transcripts, the connections, the threats, a permanent record. That's what she was building. Not justice, not revenge, just truth, documented, preserved, impossible to destroy. It wasn't enough. It was never going to be enough. But it was what she had, what she could give. And sometimes that had to be enough. The meeting with Agent Torres led to interviews. The interviews led to subpoenas. The subpoenas led to sealed indictments. Harper watched it all from a distance. She had passed the torch to people with badges and authority, and now the machinery of federal law enforcement was grinding forward at its own pace. 6 months later, Carlton Webb was arrested on charges of obstruction of justice and witness tampering. He pleaded not guilty. His trial was scheduled for the following year. Meridian Properties paid a substantial fine in a civil settlement. No admission of wrongdoing. No individuals held accountable. The company continued operating. Judge Warren Kessler retired. For personal reasons. He kept his pension. His name was never mentioned in the federal case. 3 of the 7 protected judges resigned before investigations reached them. 2 others were quietly reassigned. The remaining 2 maintained their positions, untouched by any formal findings. The system bent. It didn't break. But the record existed now. Permanent. Documented. Public. 57 complaints. 1 dissent. 1 purge. 1 infrastructure. Exposed. And somewhere in Montana, Linda Vance's daughter was raising 2 children, unaware of why her mother had run or what threats had been made. She walked with a limp. But she was alive. Sometimes that was victory enough. Harper Riley returned to her desk at the White House counsel's office. The work continued. New nominations, new files, new questions about who would serve and who would be protected. She read differently now, looked for the shadows behind the words, asked questions that hadn't occurred to her before. And every morning, she checked her phone for messages from numbers she didn't recognize, waited for the next anonymous tip, the next thread to pull. The work was never done. It couldn't be done. The system was too vast, too entrenched, too protected. But it could be documented, challenged, forced to answer for itself, however imperfectly. Harper opened her laptop, created a new folder. Backlog Purge, 2016. Closed, then created another. Infrastructure Investigation. Ongoing. The first file inside, a photograph of a man in a courthouse hallway. Face still unidentified. Ghost still unnamed. She would find him. Eventually. The work continued. That's the end of this story. But if you want more like this, subscribe and hit the bell. Every week we bring you stories of people who refuse to stay silent. Leave a comment telling me what you thought, and I'll see you in the next one. 3 months after Carlton Webb's arrest, Harper received a package at her office. No return address. No identifying marks. Inside, a single photograph. The man from the security cameras. Face finally visible. Clear, identifiable. And a handwritten note. His name is Edward Marsh. He reports to the 6th floor. And he knows you've been looking. Harper studied the photograph. The face, the note, the 6th floor. In Washington, that phrase meant one thing. A level of government that didn't officially exist. That operated in shadows behind shadows. She had been investigating corrupt judges, a conspiracy of money and influence, state-level protection of institutional bias. But this was something else, something that reached into the federal machinery itself. Harper placed the photograph in her locked drawer, destroyed the note. She didn't know who Edward Marsh was, didn't know what the sixth floor wanted, didn't know why someone had chosen this moment to send her his face, but she knew one thing. The next investigation had already begun. She opened a new folder on her laptop, labeled it with a single name, Marsh, and waited for what would come next. 18 months after the photograph arrived, Harper Riley stood at the window of her new office and watched snow fall over Washington. The view was different now. Higher floor, larger desk, a title that carried weight she hadn't asked for but had earned. Deputy White House Counsel for Judicial Affairs. The position had been created specifically for her, a recognition, the chief counsel said, of her unique perspective on institutional accountability. What he meant was, they needed someone who understood how systems protected themselves, someone who could spot the patterns before they became problems. Harper had accepted, not because she wanted the title, because the title gave her access. And access was the only currency that mattered in the fight she was waging. The Marsh file sat in her locked drawer, untouched for 3 weeks. She had learned to be patient, to wait for the right moment, to let threads develop before pulling them. Edward Marsh remained a ghost. The photograph had been enough to identify him. Former military intelligence, private sector since 2008, currently listed as a consultant for a defense contractor with no public-facing operations. His official biography was sparse, his digital footprint almost non-existent, but Harper had learned that absence was itself a form of presence. Men who worked this hard to remain invisible were hiding something worth finding. The intercom buzzed. "Ms. Riley, your 2 o'clock is here." Harper turned from the window, smoothed her jacket, prepared her expression. "Send them in." The door opened. Agent Torres entered first. Older now, grayer, carrying the weight of cases that never ended cleanly. Behind him, a woman Harper didn't recognize. Young, sharp-eyed, the kind of intensity that suggested she hadn't yet learned that intensity wasn't enough. "Ms. Riley," Torres shook her hand. "This is Special Agent Keisha Warren. She's been assigned to the continuing investigation." Warren's handshake was firm, professional. "I've read your file," Warren said. "What you built, the documentation, the pattern analysis, it's the foundation we're working from." The foundation? Harper gestured to the chairs across from her desk. "And what are you building on it?" Torres and Warren exchanged a glance, the kind that preceded bad news delivered carefully. "We've hit walls," Torres admitted. "Webb's trial ended in a hung jury. Retrial is scheduled, but his lawyers are filing motions that could delay it another year. Meridian Properties restructured. New name, new board, same operations. The 3 judges who resigned are all working as arbitrators now, making twice their former salaries. And the protected witnesses? Scattered. Linda Vance refused to testify, said she'd given you everything she was willing to give. 2 others recanted, said they'd been mistaken about details they previously confirmed. Harper absorbed this. It wasn't surprising. The system had centuries of practice at protecting itself. What about the 6th floor reference? The Marsh connection? Warren leaned forward. "That's why we're here. We've been tracking Marsh for 6 months. He's connected to something larger than judicial corruption, something that touches multiple agencies, defense contracts, intelligence operations, financial movements we can't fully trace." "Are you saying he's government?" "We're saying he operates in spaces where the line between government and private interests is blurred." Harper thought about this. The photograph in her drawer, the note about the 6th floor, the anonymous source who had chosen to expose Marsh but remained hidden themselves. "Someone inside wants him exposed," she said. "Someone with access to information about his operations. Someone who's been feeding me breadcrumbs since the beginning." Torres nodded. "We think so too. The question is, why? And why you specifically?" Harper had asked herself that question many times. She still didn't have an answer. "What do you need from me?" Warren pulled a folder from her bag. placed it on the desk. We need you to do what you do best. Document, analyze, find patterns we're missing. She opened the folder. This is everything we have on Marsh's network. Financial records, travel patterns, communications metadata. We can't make sense of it. You might. Harper looked at the folder. Thick, complex, the kind of investigation that consumed lives. This goes beyond judicial corruption. It goes beyond everything. Torres's voice was heavy. We're talking about a shadow infrastructure that touches courts, contracts, legislation, people who've built a parallel system of influence that operates outside any oversight. And you want me to map it? We want you to help us understand it, so we can dismantle it. Harper was silent for a long moment. Then she pulled the folder toward her. I'll need access to resources I don't currently have. Secure communications, analyst support, protection for any sources I develop. Done. And I'll need something else. Torres raised an eyebrow. I'll need you to understand that this won't end with arrests. It won't end with trials. The best we can hope for is documentation, a record so complete that the next generation has something to build on. Harper met his eyes. That's not justice, but it's what's possible. Torres nodded slowly. Ms. Riley, after 18 months of working this case, I've learned that possible is the only standard that matters. Justice is a direction, not a destination. You move toward it, 1 inch at a time, knowing you'll never arrive. Harper almost smiled. You've been talking to Judge Mercer. We interviewed her last month. She said to tell you she's still keeping files, just in case. The snow continued falling outside the window. Harper opened the folder, began reading. The work continued. That evening, Harper drove to a cemetery in Arlington, not the famous one, a smaller burial ground tucked away from the monuments and the tourists. The kind of place where ordinary people rested, teachers, clerks, workers who had lived without fanfare and died without headlines. She parked near the iron gates, walked the familiar path between headstones. Her grandmother's grave was marked by a simple stone. Eleanor Riley, 1931 to 2019. Beloved mother and grandmother. Harper knelt, brushed leaves from the base of the marker. I'm still fighting, Grandma, the way you taught me. Eleanor Riley had been a schoolteacher in Alabama during the Civil Rights Movement, had marched, had been arrested, had lost jobs and friends and, once, nearly her life. But she had kept going, had taught her granddaughter that the fight never ended. It just changed forms. They're bigger than I thought, the people I'm fighting. They reach into places I didn't know existed. Harper's voice was steady, the kind of steady that came from practice. But I found something, a thread, and I'm going to keep pulling until the whole thing unravels, or I run out of strength. The wind stirred the bare branches overhead. You always said the arc of history bends toward justice, but you never said it bends on its own. Someone has to bend it, push it, force it to move. She stood, looked at the name carved in stone. I'm still pushing, Grandma. I'll keep pushing until I can't anymore. She walked back to her car, drove home through empty streets. The folder waited on her kitchen table. The photograph of Edward Marsh waited in her locked drawer. The anonymous source, whoever they were, waited somewhere in the shadows. Harper poured herself tea, sat down, opened the folder, and began to read. Chotet. If you've made it this far, you're part of the story now. Subscribe, hit the bell, and share this video. Stories like this need to be told and heard. 3 weeks later, Harper made her first breakthrough. The financial records in Torres's folder contained transactions routed through 14 shell companies across 6 countries. Standard money laundering architecture, designed to obscure, to confuse, to exhaust anyone trying to follow the trail. But patterns existed. They always did. Harper noticed that certain transactions clustered around specific dates, not random dates, dates that corresponded to judicial decisions. Rulings in environmental cases, zoning appeals, contract disputes involving government contractors. She cross-referenced, built a matrix, plotted the correlations. The picture that emerged was elegant in its corruption. Money flowed before rulings. Judges ruled as expected. More money flowed afterward. A system of payment that looked, on paper, like routine business transactions, consulting fees, investment returns, real estate purchases. But when you mapped the timing, the pattern was undeniable. Marsh was the conduit, the invisible hand that connected money to decisions. He didn't threaten judges directly. That was too crude, too traceable. Instead, he facilitated, introduced, created environments where mutual interests could be discovered and cultivated. And he had been doing it for at least 15 years. Harper documented everything, built a presentation, requested a meeting with Torres and Warren. When she finished presenting, Warren sat back in her chair. This is circumstantial. A defense attorney would shred it. I know. But it's also a map, a structure we can investigate, names we can interview, transactions we can subpoena. That's what I'm offering, not a case, a starting point. Torres studied the charts she had created, the lines connecting companies to judges to rulings. If this is accurate, Marsh isn't operating alone. Someone above him is directing strategy, someone with enough resources to maintain this for over a decade. The sixth floor. The phrase keeps coming up, but we don't know what it refers to, not specifically. Harper had her suspicions, but suspicions weren't evidence. I need to meet with my source, the one who's been sending me information. They know more than they've shared. Torres shook his head. Too dangerous. You don't know who they are. Could be a trap. Could be, but they've been accurate so far. The photograph, the Marsh identification, the timing of their tips. Harper leaned forward. They want this exposed. They're inside whatever Marsh is part of, and they want out. Or they want revenge. Either way, they're my best path forward. Warren and Torres exchanged another look. How would you even make contact? They've reached out to me 3 times, each time using different methods. But there's a pattern. They seem to know when I've made progress, when I've hit walls. They appear when I need them most. Harper paused. Which means they're watching. Closely. If I signal that I'm ready to meet, they'll find a way. Torres was silent for a long moment. We can't officially authorize this. I'm not asking for official authorization. I'm telling you what I'm going to do. Warren almost smiled. And if it goes wrong, then you'll have my documentation. Everything I've built. Everything I've learned. You'll pick up where I left off. Torres looked at her with something that might have been respect, or resignation. You're not going to stop, are you? No matter what we say. Harper met his eyes. My grandmother marched in Selma when she was 17 years old. She was beaten, arrested, threatened with worse. She never stopped, not once, not for 60 years. She stood. I'm not going to stop either. The meeting with her source happened 2 weeks later. Harper had signaled in the only way she knew how, posting a specific phrase to an obscure legal forum where she'd traced one of the anonymous messages. A reference only someone familiar with the Kessler case would understand. The response came within hours. Instructions for a meeting. A location in Baltimore. A time. She went alone. Torres and Warren had argued, had threatened to put surveillance on her. She had refused all of it. This had to be one-on-one. Source and investigator. Trust built between 2 people, or nothing at all. The location was a public library. Neutral ground, security cameras, but also multiple exits, a place where a private conversation could happen in plain sight. Harper found a seat at a table near the reference section, waited. At exactly the appointed time, someone slid into the chair across from her. A woman, late 40s, professional appearance, eyes that carried the weight of secrets kept too long. Ms. Riley. You're my source. I'm a source. Part of a larger network. People inside various institutions who believe what's happening is wrong and have chosen to document it. Who are you? The woman smiled thinly. I'm someone who made choices I regret, who participated in things I shouldn't have, who decided eventually that exposure was better than complicity. She paused. My name doesn't matter. What matters is what I can give you. She slid a thumb drive across the table. This contains communications, internal memos, strategy documents. It shows how the network operates, not just Marsh, but the people above him, the structure you've been trying to map. Harper didn't touch the drive. Not yet. Why now? You could have given me this months ago. Because now you're ready. Now you have allies. Now there's a federal investigation that can actually use what I'm providing. The woman's expression hardened. Before, it would have been buried, like everything else. But you created something they can't bury, a record, a pattern they can't dismiss as isolated incidents. The sixth floor, what does it mean? The woman was silent for a moment. It refers to a specific office, in a specific building, where decisions are made that never appear on any official record. She met Harper's eyes. It's not government. Not exactly. It's the space where government and private interests merge, where the real power operates. And Marsh works for them. Marsh is a tool, useful but replaceable. The people at the sixth floor, they're the architects. They've been building this for 30 years. Harper processed this. How do I reach them? You don't. Not directly. But you can disrupt what they've built, expose enough of the network, and the architects will be forced to respond, to emerge from the shadows. The woman stood. That drive contains everything I can safely provide. The rest is up to you. She turned to leave. Wait. The woman paused. Why are you doing this? Really? A long silence. Because I have a daughter. She's 12 years old. And I don't want her to grow up in a world where this is normal, where corruption is just how things work. Her voice cracked slightly. I made choices. I can't undo them, but I can try to leave her something better. She walked away, disappeared among the library stacks. Harper sat alone with the thumb drive, the weight of what it contained, the weight of what came next. Then she pocketed the drive, left the library, drove back to Washington. The work continued. 6 months later, the first indictments were unsealed. Not Marsh, not the sixth floor, but people connected to them. Mid-level operatives, facilitators, the kind of arrests that signaled larger things to come. Carlton Webb's retrial ended in conviction. Obstruction of justice. 5 years. He would be out in 3 with good behavior, but his law license was gone forever. 2 more judges resigned. One died of a heart attack before investigators could interview him. The others faced disciplinary proceedings that would drag on for years. The DOJ investigation expanded. New field offices, new jurisdictions, a task force that reported directly to the Attorney General. Harper watched it all from her office window, the slow grinding of machinery she had helped set in motion. It wasn't justice. Not yet. Maybe not ever. But it was movement, direction, the arc bending, millimeter by millimeter, towards something better. Her phone buzzed. Text message from an unknown number. She read it, felt her breath catch. They know about the thumb drive. They're coming for you. 48 hours. Get somewhere safe. Harper stared at the message, then at the snow falling outside. She had always known this moment would come. The moment when the people she was fighting realized she had become too dangerous to ignore. She had 2 choices, run or stay and fight. Harper thought about her grandmother, about Linda Vance's daughter, about the 12-year-old girl whose mother was risking everything so she could grow up in a different world. She opened her laptop, began uploading everything, every file, every document, every piece of evidence, to secure servers in 3 countries. Copies that couldn't be destroyed, records that couldn't be erased. Then she picked up her phone, dialed Torres. I need extraction, 48 hours or less, and I need you to be ready to move on everything in the Marsh file. Torres didn't ask questions. Where do you want to go? Harper looked at the photograph on her desk. Her grandmother at 17, marching in Selma. Somewhere I can keep working. This isn't over. It's just changing form. She hung up, began packing. The work continued. Epilogue. The safe house was in Vermont. Remote, secure. The kind of place where someone could disappear for as long as they needed. Harper spent 3 months there, writing, documenting, building the record that would outlast her. The book was published the following year. The Shadow Docket, How America's Courts Were Captured. It named names, traced patterns, exposed what had been hidden for decades. The response was immediate. Lawsuits, threats, attempts to discredit her. But the record existed now, public, permanent, impossible to destroy. Judge Warren Kessler died of natural causes 2 years after his retirement. His obituary mentioned his distinguished service to the North Carolina court system. It did not mention 57 complaints. It did not mention the purge. But Harper's book did, and it remained in print. Edward Marsh was never arrested. He disappeared, or was disappeared, 6 months after the book's publication. His body was found in a hotel room in Prague. The death was ruled natural causes. No one believed it. The 6th floor remained invisible, protected, untouchable. But the architects were nervous now. Their network had been exposed, their patterns documented, their immunity shaken, if not destroyed. Harper continued working. New investigations, new patterns, new threads to pull. She never stopped, never would. Because she understood something her grandmother had taught her 60 years ago. The fight never ended. It just changed forms. Each generation picked up where the last left off, pushing the arc a little further, building on the documentation that came before. That was the work. That was the legacy. Not victory, not justice. Just movement, direction. The slow, grinding, endless effort to make things slightly better than they were. Harper opened her laptop, created a new folder, labeled it with the current date and a single word, continuing, and began to write.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.